Good morning, and welcome to the Faculty of Law and to our wonderful new facility here, the Jackman Law Building. Welcome especially to the Attorney General, the Honorable Yasir Naqvi, and Deputy Attorney General Patrick Monahan. Thank you for being here. We're thankful at the University of Toronto for the opportunity to work on the traditional land of the Huron-Wendat, the Seneca, and most recently the Mississaugas of the Credit River. At the Faculty of Law, we're also fortunate to sit on a symbolically ideal location for a law school, right on the boundary between the university and Queen's Park. Today's event nicely captures the significance of this location, and we're pleased to play host today. In addition, an outstanding educational institution is also a socially responsible institution, and we're very proud at our faculty about the Access to Justice initiatives and various clinics and other activities that we have here at the faculty. So we feel that it is indeed a fitting setting for today's announcement about new investments in the justice system. The Attorney General will make his remarks shortly and will invite questions for about 10 minutes at the microphone upon the conclusion of his announcement. Minister Naqvi has enjoyed a remarkable political career since first being elected as an Ontario MPP in 2007, representing Ottawa Centre. He was subsequently re-elected in 2011 and in 2014, and is currently also the government House Leader, in addition to being the province's Attorney General. A graduate of the University of Toronto, as you see, a Freudian slip, a graduate of the University of Ottawa Law School. We won't hold that against you. He practiced international trade law with Lang Michener LLP and Flavel Kubrick LLP, and was previously Associate Director and Trade Counsel at the Centre for Trade Policy and Law. In government, he has served as Minister of Community Safety and Correctional Services and Minister of Labour. Ladies and gentlemen, please welcome Ontario's Attorney General, Yasir Naqvi.
Thank you for being here. Well, thank you very much, Dean, for your kind introduction. I've been debating whether to say the following or not, but you started this. So yes, I am a graduate of University of Ottawa. I'm a very proud graduate of University of Ottawa because I applied to your law school 3 times. And before others could even send me their acknowledgement letter receipt, you sent me no. So it's not my fault that I did not graduate from your law school, but you started it. Good morning, everyone. I very much appreciate all of you joining us today, and I do want to thank Dean Iacobucci and the Faculty of Law for welcoming us here today in your beautiful new addition to law school, so thank you. Earlier this year, the Supreme Court of Canada sounded the alarm. Across the country, including here in Ontario, the pace of criminal justice is too slow. Criminal cases are taking too long. There are vulnerable, low-risk people in our correctional facilities who should be out in the community on bail, but are not because they lack the right supports. At the same time, there are some in our correctional facilities who should be and are detained until their trial, but wait too long for their day in court. Our criminal courts are bottlenecked, daily dockets are jammed, and early trial dates are hard to come by. This is not good for anyone. Justice delayed is justice denied for victims, for witnesses, for the accused, for all of us. This is a real and significant challenge. I'm here today to announce that Ontario is ready to meet this challenge, to take the lead and create a faster and fairer criminal justice system in our province to enhance public safety. Since the Supreme Court of Canada issued its decision in Jordan in July, justice leaders in courthouses across the province have been working together. The judiciary, Crowns, the defense bar, legal aid, our hardworking court staff have come together to identify, triage, and resolve as many cases as quickly as possible. And it's clear that the government needs to support their efforts in a significant way. That is why our government is launching a comprehensive plan to enhance public safety by speeding up criminal justice in Ontario. and make more support and supervision available to vulnerable, low-risk individuals who come in contact with the law. Our plan includes significant new investments and innovative new programs that will improve the performance of Ontario's justice system. Let me first deal with the issue of time to trial. The Jordan decision is a game changer. It requires a strong response. Beginning immediately, we will appoint 13 new judges to the bench of the Ontario Court of Justice. We will add 32 assistant Crown attorneys to our ranks. We will provide funding to Legal Aid Ontario for 16 duty counsel who will be available to provide on-the-spot help with bail to those in need. And they will be supported by 26 new courtroom staff. Our plan will help ensure that cases are resolved faster by having more assistant Crown attorneys working on cases and more judges to hear them. This will ensure faster justice for families, for victims, and for the accused. In addition to speeding up the trial process, our plan will improve another fundamental part of the criminal justice system, and that is bail. It is important to remember that Ontario is one of the safest jurisdictions in the world. Since 2003, Ontario's crime rate has dropped by 37%. In fact, Ontario has had the lowest crime rate of any province and territory every year since 2004. The reality is many of those in our correctional facilities are vulnerable and are in need of support. A disproportionate number of them are Indigenous, racialized, and have complex mental health needs. Many are not a threat to public safety. They are low risk and simply do not have the supports they need to be out of custody on bail. Holding them in jail places a huge financial burden on the entire justice sector and costs the Ontario taxpayer who ultimately foots the bill. Our action plan on bail is groundbreaking. It includes investments and innovative new policies and programs. It does three things. One, it will ensure more effective and timely bail decision-making. Two, it will provide for more bail supervision and support programs in the community for low-risk, vulnerable people. And three, it will usher in increased openness and transparency in criminal justice system. Our plan will expand the bail verification and supervision program province-wide so that there will be more support options available for low-risk, vulnerable people so that they can be safely and quickly released into the community, instead of remaining in custody waiting for a bail hearing. Our plan will also ensure that vulnerable, low-risk people have increased access to legal counsel soon after being charged so that they are prepared to move to the bail hearing stage faster, reducing the time they have to spend in custody on remand. Last, but certainly not the least, our plan involves developing a new Indigenous bail and remand program which will be facilitated by Indigenous service providers, organizations, and communities. The program will allow low-risk accused Indigenous people to remain in their communities while awaiting trial, including those living in remote communities. In addition, we have appointed 3 prominent legal experts, former Chief Justice Brian Lennox, former Deputy Attorney General Murray Siegel, and Deputy Crown Attorney Laurie Montague, to provide advice on modernizing Crown policies on bail, for example, providing advice on the use of sureties, bail conditions, and GLADU principles. To be clear, there are people accused of very serious crimes who pose a risk to community safety. These people should rightly be denied bail. However, they have a right to a timely trial which will enhance public safety. As I said earlier, we have a great challenge ahead of us. There's no sugarcoating it. While it won't be easy, I believe our plan will enhance public safety by speeding up criminal justice in our province and will make more supports and supervision available to vulnerable, low-risk individuals who come in contact with the law. As the Attorney General I'm excited by the opportunity we have to make improvements to our justice system that will last for generations to come. Thank you, and I'm more than happy to answer questions that you may have.
Time to trial initiative differ from Justice on Target?
Well, so our focus here is very targeted in terms of providing resources that will ensure that cases are being dealt in a faster manner, more from a perspective of case management and pre-trial matters. Justice on Target has been very much focused on finding those efficiencies and challenges within the entire system. But what Jordan has done is really changed the landscape. In the Jordan decision, the Supreme Court has given all of us a challenge, all partners in the justice sector. And one of the things they have asked the governments to do is to provide additional resources so that cases can be heard faster, could be tried faster. And we've been working very closely with our judiciary in determining what those resources look like, and we're responding to those needs by the announcement today. So we'll go to Mike, and then we'll come to you.
What took you so long? I mean, you've had months to deal with the Jordan decision, and in the meantime, we've had serious criminal charges stayed, basically thrown out of court. What's taken so long to act on this seriously?
Well, the Jordan decision came in July of this year. I was appointed as the Attorney General 2 weeks prior to that decision, and I can tell you that I, along with the entire Ministry of the Attorney General, has been working diligently along with our partners in the justice system, the judiciary, our crowns, the defense bar, in making sure that we have a robust and appropriate response to the landscape that has totally changed by virtue of the Jordan decision. Our partners in the justice system has been working actively from the beginning since the decision came about in terms of finding better ways of triaging and prioritizing cases. I've had the opportunity to raise these issues with our federal Minister of Justice at the federal, provincial, and territorial meetings. But we wanted to also make sure that we have a more comprehensive response to Jordan decision so that our system is faster and fairer and will enhance public safety, and that's what we're announcing today.
The decision doesn't identify any new problems. Why did it take an ultimatum from the Supreme Court to get the problems to address something that's been worsening for a long time?
Well, I mean, the Supreme Court decision speaks to the entire country. And, you know, in the decision, they've challenged everyone from judiciary to Crown and Defense Bar to the government. It's a very, it is a call for action in the decision, and they have found that there has been a culture of complacency that has creeped into our criminal justice system, and by setting some very strict presumptive ceilings around time to trial, they've given us the challenge, and we're responding. I'm very excited that we have worked very closely with all our justice partners to develop a very comprehensive approach, not only just providing resources on time to trial, but also a very comprehensive approach to how we do bail so that we can really shorten the timeframes around pre-trial custody matters that has an impact on the entire spectrum, entire process, so that we're looking at the entire system in a holistic way and ensuring that we're not clogging up our correctional facilities, that we are getting low-risk, vulnerable individuals in supervision within the community, but also making sure that there are faster trials that will enhance public safety.
So there are already bail programs in Toronto, in Kingston, elsewhere. Apart from the 20 new beds in Thunder Bay, how are you going to get more people out of pretrial detention and into the community?
So, I mean, there's a variety of things that we're announcing, which is outlined in your backgrounder. I mean, there's, I think, a couple of important things we're doing. One, we're making sure that there is more timely bail decision making in the start of the process when a person is accused and is brought to bail court. So by making sure that there is more Crown counsels and duty counsel available to work together right at the outset of the process so that one can determine what kind of conditions or sureties should be made available. That will help reduce the number of hearings that take place in many bail matters and allow for low-risk and vulnerable individuals to be able to get bail and be in supervision in the community. The other big piece we're doing is expanding our bail supervision program across the province. Right now it's about half of the province, not the entire province, so that is a very important aspect. Not to mention the bail beds you're mentioning across the community beyond Thunder Bay that will allow for individuals who cannot be on bail because they're homeless or poverty is a big issue for them, that we can provide appropriate place for them to be in the community in supervision. So this is a very comprehensive approach in that regards. I don't want to underestimate the work we will be doing over the next 6 months in revising our Crown policy when it comes to bail as well. And we've got 3 very notable experts in former Chief Justice Brian Lennox, former Deputy Attorney General Murray Siegel, and Deputy Crown Attorney Laurie Montague to advise us on revisions to those Crown policy that will help us in having a more appropriate use of sureties and bail conditions and Gladue principles.
To ask Crowns to change the way they approach bail and change the way they contest it and the conditions they ask for.
Well, so I mean that's the work we want to do in terms of the revision of our and modernization of our Crown policy, and that's why we've got 3 experts who've got lots of on-the-ground experience in dealing with these matters, who will be working with us and our ministry in giving us advice as to how we modernize our Crown policy.
Attorney General, the information I've been given is that there are 6,000 cases before the courts that on their next appearance will be past the guidelines set down by the Supreme Court in terms of unreasonable delay. Given that it's going to take you 6 months to get all of these the courtroom reforms and extra resources in there, how concerned are you that more serious criminal cases are going to be tossed out of court because of the delays that have happened up until now?
So I want to make a couple of very important points. First of all, there is no automatic right to stay. The Supreme Court in Jordan has set up some ceilings, and there's a process that one goes through it. We have been working on dealing with the issues around time to trial. As I said earlier, our judiciary, Crown and Defense Bar, and court staff has been working diligently in triaging cases and making sure cases that need priority are the ones that are working through the system. The supports that we are announcing comes into effect immediately, and we will start the hiring process immediately as well, which will have a tremendous impact as well in ensuring that we are able to deal with those cases in a more effective way. We've worked very closely with our Chief Justice of the Ontario Court of Justice, and these are the resources she's indicated she needs, and I have full confidence that she will be deploying them as quickly as possible to make sure that we rise to the challenge and provide for faster and fairer trials that will enhance public safety.
What happened in Ottawa just a couple of weeks ago? Can you guarantee the people of Ontario that no more serious charges are going to be thrown out of court because of delays?
We are responding to the challenge that's been given to us by the Supreme Court. We are presenting a very comprehensive approach to the entire criminal justice system, both in terms of important additional resources to have fairer and faster trials, but also making sure that we focus on areas that has been problematic in terms of resulting in delays, and that is around pre-trial custody in bail hearings, and making sure that we've got supports available that will allow for a faster process at the front end as well. We're confident, all the consultations we have done on this issue over the last few months, all the feedback we have received, that all these measures are going to have a real meaningful impact and will result in a faster and fairer criminal justice system enhancing public safety.
No guarantee.
What are the...
Well, I'm not the decision maker in those respects. Our judiciary makes those decisions, and I will respect their decisions always. But I want Ontarians to know that we are responding to the challenge that was laid by Supreme Court of Canada in Jordan in an expeditious and effective manner, and we're putting real, meaningful permanent solutions in place that will ensure that our criminal justice system is responsive, is faster and fairer.
Current averages for how long it takes criminal cases to get to trial. I'm wondering how far behind the Jordan time limits Ontario is currently.
Well, I have to get you those detailed numbers, but I mean, different matters takes different times. We, of course, been looking at this, the entire the system and making sure that we identify where we see there are bottlenecks or clogs in the system and make sure that we have appropriate responses to them. There's another big element of this conversation that we've already engaged with is with the federal government because, as you know, provinces are responsible for the administration of justice. The criminal law policy, by way of criminal code, is set by the federal government. One of the things the Supreme Court told us in the Jordan decision that we need to look at modernizing our criminal law system as well and to make it more simpler in nature. And this is the conversation that we engage with the federal government, and they are also launching a review of the criminal code to ensure that we've got a more modern and simpler system.
Do you have a sense of how long it might take to get Ontario criminal cases up to this standard?
We will get those numbers to you, but it varies from depending on what kind of offense you're dealing with.
There are currently 300 or so justices at the Ontario Court of Justice. You're talking about appointing 13 new ones today. It's a pretty marginal change to what you called a structural problem, a game-changing decision at the Supreme Court. Why such marginal action?
Well, so we worked very closely with the Chief Justice of the Ontario Court of Justice in getting her advice as to what kind of resources she needs. This is the number that she has indicated that she will need. It is her first number, yes.
30, and you
no, she did not actually, and you can confirm that with her. We have a very collaborative relationship with our judiciary, and we work closely. She assures me that she is going to be using these resources in a very targeted manner to deal with issues around time to trial in an innovative manner that will ensure that our cases are moving faster through the criminal justice system.
And do we have a cost for the measures that are introduced today?
Yes, the cost is approximately $25 million a year. Let me come to Jamie, and then I'll.
18 months, that's a really low ceiling. Are you going to be able to meet that?
So, Jimmy, you got to be a little louder.
That's a really low ceiling. Do you have fears that you may not be able to meet that in every case?
Well, you have to remember that what the Supreme Court of Canada said, that matters that are before the provincial courts are 18 months, and the matters that are serious in nature that go to Superior Court of Justice, the timeline is 30 months. So they've laid out two different time frames for different levels of courts. The fact of the matter is that they have asked governments, judiciary, councils in the system, to everyone to act, to really address the issues around delays within the system, to ensure that we always protect the rights of the accused in terms of unreasonable delays. And we're responding to that. We're responding to that by not only investing new resources in the system to expedite our criminal justice system, to make it faster and fairer, but also by making sure that we have an action plan that deals with bail, around pre-trial custody, and see that we can relieve pressures of our correctional facilities, also have appropriate supervision for accused in the community, those who are low risk and vulnerable, and expedite the process from the very beginning when an individual comes in contact with the criminal justice system.
But it's still a pretty low goal. You're going to have a tough time. There's going to be a tough time meeting every case at 18 months provincially.
Well, we're determined to meet the challenge that was set by the Supreme Court of Canada. As I said in my remarks, that this is not going to be easy work, but it's a work nonetheless that we are committed to doing, and we are putting real resources and real strategies behind it.
En français, pouvez-vous...
A one-on-one, we can do that en français. Oui, okay. Thank you.